Ready, start. The Advocates Act, 1961 has been enacted to amend and consolidate the law relating to legal practitioners and to provide for the constitution of bar councils and all India bar. Full stop. Section 16 thereof states that there shall be two classes of advocates, namely, the senior advocates and the other advocates. Full stop. Section 30 thereof, inter alia, provides that subject to the provisions of the said act, every advocate whose name is entered in the state roll shall be entitled as of right to practice throughout the territories to which the said act extends, in all courts including the Supreme Court. Full stop. Chapter 5th of the said act pertains to the conduct of the advocates, and section 35 and 36 empower the State Bar Council and the Bar Council of India to take disciplinary actions and punish the advocate who has been found guilty of professional and other misconduct. Full stop. Section 49 thereof empowers the Bar Council of India to make rules for discharging its functions under the said act and in particular for the matters prescribed therein. Full stop. The Bar Council of India, in exercise of its rule-making power under the Advocates Act, 1961, has framed the rules called the Bar Council of India rules close. Full stop. The said rules have been divided into 9 parts. Full stop. Part 6th pertains to the rules governing the advocates. Full stop. Chapter 1st of the said Part 6th lays down the restrictions on senior advocates in the matter of their practice of the profession of law as mentioned in Section 30 of the Advocates Act. Full stop. Chapter 2nd of Part 6th pertains to the standards of professional conduct and etiquette to be followed by the advocates. Full stop. The said chapter lays down the duties of an advocate to the court, to the client, to the opponent, and to the colleagues. Full stop. Chapter 4th of Part 6th also prescribes the form of dressage or robes to be worn by the advocates. Full stop. It may further be noted that under Article 145 of the Constitution of India, the Supreme Court is empowered, with the approval of the President, to make rules for regulating generally the practice and procedure of the court, including the rules as to the persons practicing before the court. Full stop. Accordingly, the Supreme Court has framed the Supreme Court Rules 2013, which came to be amended by the Supreme Court / Amendment Rules, 2019, hereinafter referred to as the said rules, close. Full stop. From the above stated statutory provisions, what is deducible is that the Supreme Court, in exercise of the powers conferred by Article 145 of the Constitution of India and all other powers enabling it in this behalf, has made, with the approval of the President, the rules for regulating generally the practice and procedure of the court, including the rules as to persons practicing before the court. Full stop. Therefore, though an advocate whose name is entered on the roll of any state bar council maintained under the Advocates Act, 1961 is entitled to appear before the Supreme Court, his appearance would be subject to the said rules of 2013 framed by the Supreme Court. Full stop. The proviso to Rule 1 (a) of Orders 4th restricts an advocate from addressing the court for the purpose of any effective hearing, if his name has been entered on the roll of any state bar council for less than 1 year. Full stop. Of course, he is entitled to mention the matter in the court for limited purpose of asking time, date, adjournment and similar such orders. Full stop. As per rule 1 within bracket B, comma, no advocate other than the advocate on record for a party can appear, comma, plead and address the court in a matter unless he is instructed by the advocate on record or permitted by the court. Full stop. Rule 20 thereof states that no advocate on record shall authorize any person whatsoever except another advocate on record, comma, to act for him in any case. Full stop. Rule 2 within bracket B mandates that a senior advocate shall not appear without an advocate on record in the Supreme Court and shall not appear without a junior in any other court in India. Full stop. Thus, comma, as per the said rule, so far as Supreme Court is concerned, comma, a senior advocate cannot appear without the advocate on record appearing on behalf of a party. Full stop. It is pertinent to note that as per rule 7 within bracket C, no advocate other than the advocate on record is entitled to file an appearance or act for a party in the court, comma, and rule 7 within bracket A requires an advocate on record to file his memorandum of appearance on behalf of a party accompanied by wakalatnama duly executed by the party. Full stop. Where the wakalatnama is executed in the presence of the advocate on record, comma, he shall certify that it was executed in his presence. Full stop. If the advocate on record has merely accepted the wakalatnama, comma, which was already executed in the presence of a notary or an advocate, comma, he has to make an endorsement thereon that he has satisfied himself about the due execution of the wakalatnama. Full stop. Meaning thereby, comma, every wakalatnama has to be executed by the party in presence of the advocate on record or in presence of a notary or an advocate, comma, for being sent to the advocate on record. Full stop.